Hello, welcome. I'm Peter Afrasiabi and I filmed this program a couple of years ago. Hollywood's Private Investigators, How PI Scandals Entrap Lawyers. I've reviewed the program and I can confirm it is still current, so please enjoy it. Hello, today's presentation is Hollywood's Private Investigators, How Private Investigator Scandals Can Entrap the Well-Meaning Lawyer. This is in essence PI Law 101. It's important for all sorts of lawyers to learn. It's not just the litigator who hires the private investigator in a contentious piece of litigation, but it's also potentially the transactional lawyer who wants to gather intelligence on an adversary in a deal, or the divorce lawyer who wants to gather intelligence and information on the other spouse. All of these situations can cause us to hire private investigators to go gather information and do that sort of informal discovery, to get some background, some ammunition, dirt, whatever you want to call it, all of which is historically part of what lawyers do in terms of preparing our case and gathering our arsenal of information. Now, if you go back 100 years to the time of, Sherlock Holmes and Dr. Watson and Sir Arthur Conan Doyle's, literary creations, the world was much less regulated legally. So Holmes and Watson would go off and put on disguises and deceive people and do all manners of things to gather information in a world that was less regulated. But if you fast forward to our century and our time, we are in a highly regulated world where all manner of behavior is regulated, all manner of conduct is regulated. We have electronic tracking and video phones and cell phones and recording, and all of these things touch now upon a modern legal world which is highly regulated. And so the result of this is that as we hire private investigators and ask them to go out in today's world and gather information that may help us, we are potentially touching upon myriad different legal regimes. And those different legal regimes that the PIs are interfacing with are regimes that you, the lawyer, must be familiar with and aware of, because ultimately, under most of the case law, you become responsible for serious misdeeds of the private investigator. So with that, let's get started. As you see on the first slide, the issues we are going to confront and the big picture deliverables today are the following. We're going to look at the relationship between the attorney and the investigator, and this relationship is critical. It's critical not just for the fate of your case, but also the reputations, the careers, and the futures, potentially of both the lawyer and the investigator. And those reputations can hinge on what may seem at the time like a minor issue, but they can become massively important issues and have really huge blowback for you as a lawyer, your reputation, your career, even potentially touching upon ethics violations down the road if you're not careful. The second issue that's relevant here is that the investigator has to understand what you, the lawyer, want done. And you, the lawyer, therefore, must be well-versed in this increasingly complex group of applicable federal, state, even sometimes local laws and regulations that define sort of the boundaries of permissible behavior by private sector investigators who are out doing what they need to do for you. And finally, the lawyer has to adequately inform the investigator of really all the relevant circumstances and review the information required, but also how it will be obtained. And one of the lessons here that we can talk about early on that you will see as we walk through this program is that you, the lawyer, you cannot be an ostrich. You can't stick your head in the ground and ask an investigator to go out and gather information, and when they come back with a whole treasure trove of amazing stuff that seems incredibly secret that they found for you, you don't get to not ask how they got it and act willfully blind. And so that's a very, very important principle to keep in mind that becomes a limiting principle in terms of the need for using extreme caution in hiring and managing investigators as they go forward. So let's go to the next slide, and where we're going to start is an understanding of the private investigator, the agent you're hiring to go out and work. And it is a highly regulated industry in most states. Here, prototypically, we're looking at California. And for someone to become a private investigator in California, they need 6,000 hours of paid work under the supervision of another who's already licensed engaging in this work. And this comes from the California Business and Profession Code, Section 7250. A variety of other provisions fall out of this Business and Profession Code series of laws here. That is, that it's illegal to imply that one is a state or federal official. That is for the private investigator when they're out doing their work. It's illegal for them to trespass, to hack, to engage in bribery, or to harass people to gather information. It's illegal to tamper with the mail, and that, by the way, is both under the California Business and Profession Code, but also under some federal laws. And critically, as we will explore in some case law, it's illegal and unlawful under the Business and Profession Code for a private investigator to perform any act of dishonesty or fraud in their efforts to gather information. And that, as you can imagine, is very malleable language and very, very broad in terms of its impact and import, in terms of how far PIs can go to gather the information you want them to get. Knowingly hiring someone who is unlicensed is a misdemeanor. And so if you, the lawyer, hire a private investigator and the person's unlicensed, but they're a friend of a friend, you know they're going to give you a good deal, you want to help them out, you trust them, they're just gathering some low-level information. That information they go out and gather for you, when you knowingly are using them to engage in this investigative work for you, you may well run afoul of this and have knowingly hired an unlicensed person and be subject potentially to misdemeanor charges under California law at least. So the critical thing here is that if you are going to hire a private investigator who by and large becomes your agent, you need to ensure that they're licensed, bonded if that's required, and that they will not engage in a whole litany of behaviors that they're not allowed to engage in. Some of the consequences that we'll talk about if you hire one who engages in misdeeds involve things such as potentially evidentiary preclusions, i.e. the fantastic material they gather for you illegally, you won't get to use. Ethics violations for you, the lawyer, if they've tripped wires and engaged in other illegal behavior. Or even potentially third-party negligence claims just for simply hiring someone negligently who ran afoul of someone else's rights. And that can happen if things get particularly ugly and you get dragged in. We don't want to get dragged into anything, and so we are going to now turn to the lawyer's legal duties. And the fundamental question is, are you, the lawyer, the insurer, in effect, of the work of the private investigator? And while you're not an absolute insurer, you come very close to it. And so here are the key points. The first is that the actions of your agent acting under your direction can be imputed to you. And so there's a duty to supervise. And this, for example, comes from the California Rules of Professional Conduct. We have Rule 3-110A, and it requires that you, the lawyer, have a duty to supervise your agents. You can also look at, for example, the American Bar Association has a Committee on Ethics and Professional Responsibility. And if you want to Google it, you can find a very interesting formal opinion. It's Formal Opinion 95-396. And effectively, it deals with the situation of an investigator acting as the lawyer's alter ego. And the lawyer becomes ethically responsible for the investigator's conduct in a wide array of settings under this ABA guidance provision. So it's an important formal opinion to read to understand some of the metes and bounds of how the ABA looks at this, which of course can influence how state disciplinary committees interpret state rules. The second point is that criminal and civil cases that we will look at and discuss today can demonstrate that the ethics obligations are but one area of concern for the lawyer, and really the problems can transcend that, and they can involve both civil exposure for you, but even potentially criminal exposure. And fundamentally, the third point is that even if what you've done doesn't trip civil and criminal laws, you can certainly have evidentiary exclusions which come back to haunt you and create problems for your case, which is another way of saying creating problems for you and your client relationship and potentially a malpractice claim blowing back against you. So all of this is the lead into why it becomes important for you, the lawyer, thinking about hiring a private investigator. Since you're going to have responsibility, you must know the different legal regimes that this agent of yours will be operating in. And so we're now going to turn to all these different legal regimes. And so if we go to the next slide, you can see that The work of a private investigator really creeps over, as we say here, and covers a tremendous number of different legal areas. And these are both civil areas, they're criminal areas, they're state laws, they're federal laws. So it's a whole panoply of legal regimes that you have to be aware of. The list here is not exhaustive by any means. It is highly inclusive of most issues, but there are certainly other issues and areas out there that one has to be aware of. These are the biggies, though, that we're going to talk about today. And they're a function of the modern world, as I alluded to in the beginning, and where we live. And so one of the areas involves GPS tracking. Everyone has a phone, we have GPS on our phone. GPS has become just a very common technology. And so you need to be aware that there are legal regimes, criminal legal regimes, that deal with whether you're allowed to, just put a little GPS on someone and follow them and where they're going. There's also a federal regime that deals with the Federal Driver Privacy Protection Act, and that just regulates driver license, vehicle registration information, and such information as that, and when and how it may be accessed. There are federal and state computer hacking laws that we will look at that deal with the ability to, through a computer, access and gain information that you may not have permission to access or you may not have authority to even be on. There are a whole variety of federal and state laws related to recording someone without their consent, audio recording with or without consent, that one has to be aware of. There are, of course, state laws that track and cover whether you can film someone inside their house, even if you're standing on a public sidewalk, our invasion of privacy laws. And then there is a body of law that also here is dealing with your ability to lie to people or to, fake who you are and create fake personas in order to trick people into giving you information. And that can trigger fraud-related claims and invasion of privacy claims, because although lying in general has been held protected by the First Amendment by the Supreme Court, it doesn't apply in non-commercial speech and in a non-commercial context, such as what you'd be engaging in with a private investigator. And of course, then there are some ethics bar rules. Now, all of this litany of legal regimes that you see here on the slide all relate to really sort of the most basic ways that information could be gathered outside the traditional discovery process of serving, reciprocal demands for information on someone in a case. And so with that, let's get started. Given this vast number of laws, there are a myriad ways of gathering information. It's fully regulated across all legal regimes. And these fact-gathering activities and techniques require knowledge and caution. So let's get going on tracking and GPS. And so as you see here on our slide number 7, we're going to talk about GPS and the California Penal Code. And this is section 637.7. The general rule is as follows. No person or entity in this state shall use an electronic tracking device to determine the location or movement of a person. As used in this section, electronic tracking device means any device attached to a vehicle or other movable thing that reveals its location or movement by the transmission of electronic signals. A violation of this section is a misdemeanor. So this is a California criminal law that has made it a crime to attach some sort of GPS beacon to someone's car or to someone's person or to their bicycle or truck or airplane in order for you to track them. Now, there are some limited exceptions to this law, and that is that law enforcement, obviously pursuant to appropriate criminal laws and warrants and judicial approval and whatnot, can GPS track if they need to. And also there's an exception for you, the registered owner or the lessor or lessee of a car with consent, can put a GPS tracker on your own car, for example, LoJack and those types of technologies. But you can't do that to someone else's car. So what's the point of all this? If you want to follow someone in this day and age, you got to do it the old school way, the way Sherlock Holmes did it back in the novels. You have to literally follow them. You can't just be lazy and rely on technology and stick a GPS tracker and virtually track them and follow them. You've got to do it the old-fashioned way. An important law to be aware of, as many have run afoul of it and found real criminal problems. The next issue we turn to is a common thing, You go to the PI and you want to gather some background information on the person, and you just want to know, get me a profile on them, get me the information, some general thing like that, you may say. And what you want to get is kind of the driver's license, vehicle registration, addresses, all sorts of stuff, right? And the PI may, used to be a police officer or an FBI agent and has buddies at the DMV still, and they just kind of help him out behind the scenes, that whole sort of culture that often exists, and certainly existed in years gone by. And so they say, hey, go get the information from your buddies down at the DMV. Well, you have a problem. And that problem is, as you see here on this slide, the Federal Drivers Protection Privacy Act of 1994. This is at 18 U.S.C. 2721, and it's a federal law that limits when state departments of motor vehicles may disclose personal information contained in a person's motor vehicle record. Now, the kind of personal information that may be in a motor vehicle record includes title information on the car, that is, who it is titled to, actual registration, where it's registered, the name, the address, location, and even identification cards, including, your driver's license, a copy of your driver's license. It includes photographs, even the very photograph that the DMV took of you that's in their archives. That's the type of information that's protected by the Federal Drivers Protection Privacy Act. Social security number that may exist within the DMV, driver's license numbers, even your name and address. Although interestingly, under the federal law, the zip code isn't included and isn't a part of it. But phone numbers are, as is medical information. And if you pause there for a second, it's important to think about that. We all know that a variety of people have a variety of disabilities or medical conditions that relate to driving that don't necessarily preclude them driving, but may be recorded within the DMV, such as someone has epilepsy, or someone has, they're a donor and they choose to donate their organs in the event of a fatality in an accident. That kind of private medical information is also protected, and it's something you have to be careful about tripping over. Now, again, there are exceptions for when that information within state department motor vehicle databases can be given out. The exceptions include legitimate law enforcement requests or needs for their investigative work. A subpoena, so if you're in a piece of litigation and you want to get that information on the adverse party, you of course can serve a subpoena on the DMV, and you and the opposing lawyers can hash out whether it's relevant and accessible and legitimate for you to see. Insurance investigative claims is another exception. So if you're involved in representing an insurance company, for example, and the insurance company needs to investigate a claim that's been pressed, there it becomes legitimate to secure that kind of information. And then, of course, the universal exception is if you can get consent. Now, one thing to be aware of is that various states regulate their own state-gathered, obviously, Department of Motor Vehicle information, and some regulate it more inclusively than the federal government. So, as well as being aware of this federal act, you need to be aware in any given state you may be in that there may be a state-related Department of Motor Vehicle law that regulates even more highly the area and so may circumscribe even more the circumstances under which you can gather the information, or it may limit the exceptions for those who may be immune from the law, for example. So you got to be aware of both legal regimes. The practice pointer here is, if you're hiring a private investigator, don't ask them to get that kind of information. And if they come back to you with a driver's license number, vehicle title, vehicle registration, at that point, you're on notice that they have probably tripped this federal law or a state law, and you have a problem in terms of their investigative techniques, so to speak. So, let's go to the next topic, and this gets us to a big topic in press today, and in legal press, and in conventional press, and that is hacking. And so how does this come up for you, the lawyer, gathering your information? Well, it comes up because, you know, you're sitting here, you're in a contentious potential case, and you know, wow, the smoking gun document I need, it's on their laptop. And so the investigator goes off and does something and hacks in order to get it, and now you have a huge problem. And so we need to walk through some state and federal laws here and some case law so you can understand these very difficult and hazy lines, and these are emerging and changing lines in real time in real case law in terms of, you know, what constitutes hacking and what does not. We'll start on the state side. And so here you can see we have California Penal Code Section 502. Under 502, it is a crime to knowingly access and without permission take copies or make use of any data from a computer system, or computer network, or to take or copy any supporting documentation, whether existing or residing internal or external to a computer system, or computer network. So it's a penal code and a criminal violation, but there's also state provisions that create civil liability if you violate it too. And so there's two cases that we're going to look at and talk about today, both coming from California, interpreting this law, and they create arguably some confusion as to the scope of the law. But the bottom line is that there is a general rule that distills here, and the general rule is that you need to ensure that if information is gathered, it is gathered where someone has done it with the right to access the computer system and without violating those terms of use in terms of the access. That's the safest rule. So let's turn to these two cases. The first case is called People versus Lawton. This is reported at 48 Calap 4th, page 11, and it's from 1996. The facts of that case were as follows. There's a public library. Library patron goes in and gets on the computer, and we all know there are computer terminals in the library that you can use to search the card catalog database to look for the book that you want to check out and that type of stuff. And so the computers are computers, they're networked, but you, the user in the library, have, you know, very limited functionality in terms of what you can do and access. Well, this person was very good with a computer, and so he sat down at a public terminal where he could search for a book, but was able to, just by being at the computer, bypass security and penetrate levels of software not open to the public. And he ended up, in effect, hacking, as we would say colloquially, but going into areas that he was not allowed to go into. This was discovered and discerned by folks at the library. The police were called, the person was arrested for, you know, engaging in unauthorized access, was then prosecuted, the case went to court, and was convicted, and challenged his conviction on the basis that I didn't engage in any knowing access without permission, because what I did was get on a public terminal that I had every right to get on. And so if I have the right to be on the public terminal, the fact that I may use the computer to go somewhere I'm not allowed to go doesn't make my behavior without permission. And that was the argument. The California Court of Appeal rejected that argument and said, no, that is an example of unauthorized access. Now, we will pivot to this next case, because this next case helps illustrate the metes and bounds of this principle and how the area can get a little more murky. So the next case is called Chrisman versus City of Los Angeles. It's reported at 155 Calap 4th, page 29. And this is a 2007 case. And this is a case that actually comes out of the use of a private investigator. And so, you know, private investigator wanted to gather some information, and so went to a police officer buddy of his, because they're all broadly in the law enforcement space, and so that's how much information often gets gathered. and asked the police officer to gather some information. And so this is what the police officer did. And the case involved ultimately a prosecution of the police officer. The police officer logged into the police computers that he had every right to log into and gathered information that he had the right to gather to perform his police duties, but he gathered it for non-work related reasons to give to the private investigator. And so what you have contrasting a library case is accessing a computer that one has the right to access, just as the library patron had the right to access the computer. But here, the police officer exceeded some contractual prohibition on what he was supposed to do, but he had every right to touch, look at, access that information about the people. He just didn't have the right to give it to third parties. And so that case, he was prosecuted, convicted, and the Court of Appeal there said, no, that's not a hacking violation. And so the conviction was reversed. So what we get from this is the general rule, and that is that access to a computer system to gain information where one has authority to access for certain reasons, if you do access that information that you have the right to look at for certain reasons, you won't violate Section 502 even if you look at that material and gather it for other purposes. Now, you may not have hacked, but you certainly have violated contractual prohibitions, potentially right of privacy violations, and you will be fired, as a policeman experienced, but you won't be in prison for hacking. Now, if you access a computer system that you never had authority to access, then you will face a hacking problem. And so that's why the library patron was convicted, because he only had a right to be in a subset of the computer, and the moment he entered a new area, that was an area he never had authority to be in, and he had gone over a wall. Now, we shift to federal law, and we have the Computer Fraud and Abuse Act, and this is found at 18 U.S.C. Section 1030. And this has a general rule that's very similar. It prohibits acts of computer trespass by those who are not authorized users or who exceed authorized use. It can create criminal and civil liability for whoever intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains information from any protected computers. Now, it does differ to our state law that we looked at in two different ways in terms of how it's violated. Number one, obtaining access without authorization or after access rights are revoked can trigger the law, or obtaining access with authorization but then using that access improperly can create problems too. So the bottom line result is that no intrusion of any kind into anyone's computer to gather the proof, even if it is a system that is okay to access for some reasons. You just don't want to do it and find yourself on the receiving end of civil or criminal cases. So you want to exercise extreme vigilance here in making sure that this is not happening by the use of your private investigator. And so the safety tip offered is that today in our modern world, because we have computers and phones in offices, so much evidence that we want in litigation, for example, in our cases, relating to our legal disputes in terms of who said what when. So much of it in this modern world really does fall into heavily protected areas, such as computers or phones within offices. And so the answer to that is legal discovery. If you go in the extrajudicial route of private investigative techniques to get into those systems, you may well be tripping these complex, nuanced lines. Now, as we look at the next slide, we're going to start looking at two Ninth Circuit cases. These are both coming out of the Ninth Circuit out in California, dealing with the Computer Fraud and Abuse Act and highlighting two different places on the spectrum in terms of whether behavior violates the CFAA. The first is called Nosal, and this case is reported at 676 F3rd 854. It's from 2012, and it's an en banc decision of the Ninth Circuit Court of Appeals. And so these are the background facts. There were some existing employees working at a company, and they had credentials to log into the computer system because they were employees. And they had a buddy who no longer worked at the company and was setting up a competing business. And so the buddy came and said, hey, hook me up. Can you get me some of the customer lists, pricing information, that type of stuff? And so the existing employees logged into the network and system that they had the right to log into. They used their credentials to get access, and then they looked at this information. And the information was information they were allowed to look at, but they were allowed to look at it for business purposes. And so they looked at the information, even though there was a corporate policy that forbade disclosing that information outside the company, they violated the policy. And they handed over these customer lists and other trade secret information, sort of confidential, proprietary corporate information. They handed it over to their buddy. And it became sufficiently significant that it came to the attention of the United States attorneys, who actually prosecuted the employees, one of which was named Mr. Nozzle. And so Nozzle gets prosecuted for violating the CFAA. And so this is a criminal case under the criminal provisions. The civil provisions track the same language, but this was actually a criminal case, like our California library patron case and our California police officer case we just talked about. Only now we're in federal court. So, criminal indictment is brought, and the defendant files a motion to dismiss. And the defendant argues that my actions, even if true, could never constitute exceeding authorized access. And that, of course, as you saw in the prior slide, is the key statutory language. And the argument was that I had every right to access that information, to look at it, to use it, and I may have violated some contractual term of my employment from my company, but I can't be deemed to have exceeded authorized access. And more colloquially, you can't say I hacked. That's not hacking. That may be something else, but it's not hacking, which should put me in prison. And the district court agreed and dismissed the indictment. It went up to the Ninth Circuit, and the Ninth Circuit actually reversed and said, no, you could go to prison for that. And that is what then prompted the case to go en banc in the Ninth Circuit, at which point the en banc court of the Ninth Circuit came to the same conclusion as a district court and said no. And so the bottom line is that the CFAA targets unauthorized procurement of information, not authorized access to systems where the authorized access may lead to a misappropriation. It really only covers the actual unauthorized procurement on the front end. And so the holding is that those with access rights to a system don't trip the Computer Fraud and Abuse Act when they wander to areas that they're really not allowed to be in. Now, this is especially important, as the Ninth Circuit held, given our modern world and the modern internet era, where just as the employees in the Nozzle case had contractual terms and conditions that governed what they could do with information, every single person who uses Instagram and Snapchat and Facebook and LinkedIn and all manner of websites, there are terms and conditions which technically are contracts that we're all bound to when we click I accept, even though no one reads them, obviously. But in all of those, there are all sorts of prohibitions on what you can do with the information on Facebook. And you can't reproduce it and copy it and paste it, and you can't use it for commercial purposes. And the Ninth Circuit was very concerned with the idea that there could be a holding here which would turn all of us into criminals when we breach terms and conditions of use. And so that sort of major systemic policy concern is what led to this narrower interpretation of the language, because of the concern of converting everyone into a criminal, basically. The example actually given in the case was that Facebook has an actual term and condition that doesn't allow third parties to log into your account, even if you give them permission. And so the court said, okay, so what happens when husband tells the wife, log into my Facebook account and do something? Everyone's violating the terms and conditions. Are we really going to allow criminal prosecutions? And more importantly, are we really going to just trust the judgment of a prosecutor to, not exercise judgment and do it? And the answer was no, we're not. And so they interpreted the law that way. Now, pivoting this, the bookend to this is the next case we're going to look at, which is Facebook versus Power Ventures. And this is a more recent decision from 2016. And here it was a situation where it's a civil lawsuit under the Computer Fraud and Abuse Act. And the facts are as follows. Power Ventures is a company that wanted a whole bunch of people to join it. And its business model was basically sign up with us and create an account. And then we will go out and gather all of your social media data from all your different social media accounts and pull it all up into one page, one portal. And so it's sort of an aggregation business, which could be very useful for someone who may have an Instagram feed and a Snapchat feed and a Facebook feed and a LinkedIn feed and all that stuff. Rather than going to each of those places to see what's going on in your sort of online social media world, you could go into one place through Powers Ventures and it would pull up all the data for you and you could see it all. And so that's the business model. And so Powers begins a promotional campaign and they wanted to get Facebook users to join. And so they signed up Facebook users, and then they gave the Facebook users some sort of benefit if they could sort of in effect borrow the Facebook user's account within Facebook and then blast out emails and LinkedIn or join me or friend me or whatnot type messages to get other users to join. So in doing that, they were taking and using and copying data from within Facebook in order to fulfill these campaigns and using their sub-users who were already Facebook users to do it. Facebook learned of this and said this violates our terms and conditions. Our users can't engage in that type of commercial activity for Powers. If Powers wants to advertise in our network, they need to sign up with us. And so Facebook sends a cease and desist letter to Powers telling them that they're not allowed to do it. As a third party, they're not allowed to piggyback off of existing Facebook users to do that kind of advertising. If they want to do advertising on Facebook, they got to sign up and pay, in essence. And they got a cease and desist letter. Facebook also notified them that they were blocking their IP addresses so that they could no longer come into the Facebook network and do this. So, and this is what's important, what Powers then did was they switched all their IP addresses so they could get around Facebook's block, and they maintained this campaign. And so the question before the Ninth Circuit was, okay, is this a computer trespass under the CFAA? And the statutory issue, as you see on the slide here, that the court had to address was this a knowing access of Facebook's computers and networks without authorization? And so here's the holding of the Ninth Circuit. And it's very, very important because it illustrates this nuanced difference between when you have access and when you exceed access. And so the Ninth Circuit held that the initial engagement, in effect, between Power Ventures and the Facebook users, whereby the Facebook users allowed Powers to use the Facebook users' accounts to then go out and do commercial advertising within Facebook to get people to sign up, that was not improper. It was a violation of Facebook's terms and conditions, but this was not an act of one exceeding access rights such that you could violate the CFAA and be subjected to civil liability. It was like the Nozzle case. It may create contractual problems, but it wasn't a civil hacking violation. But what the Ninth Circuit said is that once the cease and desist letter issued, that rescinded Powers' right to use any of the Facebook users' accounts, even though they were Powers' clients. It rescinded that right to use those accounts for these advertising campaigns. And so at that point in time, the continued access to the Facebook systems was now without authorization. At that point, once they had specific targeted knowledge, not just some general term and condition, but they had been specifically put on notice that they were no longer allowed to access Facebook in this way, that act of then continuing to access did in fact violate the Computer Fraud and Abuse Act. So it's a very, very important case, and it's the most recent word from the Ninth Circuit on the contours of the CFAA. If you're looking at this and interested in understanding the contours of when an investigator may be hacking or not, you need to stay abreast heavily of the Ninth Circuit law. This is where a lot of the law is developing candidly in this area. There's a massive case that was argued in the Ninth Circuit in the summer of 2017 The decision as of November 2017 is not out yet, but you need to stay attuned for it because this case involves a big, massive battle between Oracle and Rimini over claims by Oracle that Rimini's competitive business behavior violated both the federal and state hacking statutes, and that one is one that people in this area are heavily waiting to watch to see what comes down. So one way to look at the hacking and to keep in mind, because the computer systems are obviously complicated, especially when you start talking about social media and internet. Here's a great quote from the Ninth Circuit, and this is what the state cases and the federal cases in California do, and you'll see it in cases in other jurisdictions dealing with hacking. They look to real world analogies, brick and mortar basically, but simple analogies to understand this conduct and to contextualize it in things that judges and lawyers are more familiar with, such as brick and mortar breaking and entering, so to speak. And so here you have an example, and this is what the Ninth Circuit did in the decision. It said, look, let's look at this in the brick and mortar world, and imagine that you have a person who wants to borrow some friend's jewelry, and the jewelry is held in a safe deposit box at a bank. So the friend gives permission for the person to access the safe deposit box and lends him a key. Upon receiving the key, though, the person decides to visit the bank while carrying a shotgun. The bank ejects the person from its premises and bans his re-entry. The gun-toting jewelry borrower could not then re-enter the bank, claiming that access to the safe deposit box also gave him authority to stride into the bank holding a gun. In other words, the Ninth Circuit said here, to access the safe deposit box, the person needs permission from both his friend and from the bank. And so, analogizing now back to Powers, the court said, similarly, for Power to continue its campaign using Facebook's computers, it needed authorization both from individual Facebook users, who controlled their data and personal pages, and from Facebook, which stored the data on its servers. So, on the next slide, we can talk here about how we harmonize these two cases. And so, exceeding authorized access is generally not violative. Accessing without any authority is what's actionable. Now, this exceeding versus without line is a very fine line. One who has the right to see, access, or touch data, but then does something improper with it, doesn't necessarily trip the CFAA. One who has no right to access, see, or touch, and does so anyway, will trip it. The problem here, of course, for you is that if you get an investigator who may go out and have someone come close to this line of tripping the CFAA, you may find yourself on the receiving end of some civil and criminal claims, and you may come out of it okay, but you may find yourself then with some ethics problems for having come too close to a line. So you want to proceed with extreme caution here, and really the safest advice is, if you're hiring an investigator, don't engage in any kind of behavior, whether it's with or without hacking under these statutes. You just want to avoid even taking a risk. Do it the traditional route, get it in discovery. So now we're going to turn to audio recording someone. You have an investigator who wants to gather information on someone, and maybe it's someone who is claiming that they've been severely injured, and you want to go out and surreptitiously audio record them where they're going to be boasting about how they're not injured or something like that. It could, 1,000,001 different ways this could come up. Well, audio recording someone without their consent is also regulated. It's regulated by states, and it's also regulated by the federal government. And so we'll talk about the states first, and states do regulate your ability to call without consent. Some states are a one-party rule, and some states are an all-party rule. And so California is exemplary of the all parties rule, and that is that before you record someone, audio record someone, all people on the call must consent to it. If they don't, it's a civil and a criminal violation. And the criminal violation can be a $2,500 fine, and it can lead to 1 year in prison. And this is California Penal Code section 632. Now remember, you can never record anyone as a non-participant unless the participants to the call know that you're actually recording them. So even if you happen to find yourself in a one-party recording state where one party can record someone without consent, you can't be a third party listening in, recording them. Now, if we turn to the next slide, you can see here's a breakdown of some of the states. All party states are California, Connecticut, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, Nevada, New Hampshire, Pennsylvania, Washington. The other 38 states are one-party states, including DC, and also federal law is a one-party statute. So the tip here is that don't ever record without consent pre-recording if the jurisdiction doesn't allow it. There's civil and criminal exposure. And don't ever record as a non-party via your private investigator. And we'll talk about that soon in the Pelicano and Christensen case coming out of Hollywood that landed a lawyer in federal prison disbarred. The next issue we're going to turn to is, well, I'm on a public sidewalk. I want to video record someone or take a photograph of them and, or drone record them and with our modern drone technology. And that's got to be fair game, right? I'm on the public sidewalk and I'm just looking down. I mean, their house, you can see it from the public sidewalk. I can see into their living room. Surely I can go and record it or take my drone to record what they're doing in their backyard. Well, the problem here is that you run afoul of privacy laws, and the California Penal Code here's an exemplary articulation of a privacy law. Any person who looks through a hole or opening into or otherwise views by means of any instrumentality, including but not limited to a periscope, telescope, binoculars, camera, motion picture camera, or camcorder, the interior of a bedroom, bathroom, changing room, fitting room, dressing room, or tanning booth, or the interior of any other area in which the occupant has a reasonable expectation of privacy, if done with the intent to invade that privacy, it's a criminal violation. And so the civil provisions here in the California Code of Civil Procedure, they're quoted next. This comes from section 1708.8. And it says that a person is liable for physical invasion of privacy when the person knowingly enters onto the land or into the airspace above the land of another person without permission or otherwise commits a trespass in order to capture any type of visual image, sound recording, or other physical impression of the plaintiff engaging in a private, personal, and or familial activity, and the invasion occurs in a manner that is offensive to a reasonable person. The related provision here is that, and this is again under 1708.8, is that a person is liable, and this is again the quote, for constructive invasion of privacy when the person attempts to capture in a manner that is offensive to a reasonable person any type of visual image, sound recording, or other physical impression of the plaintiff engaging in a private, personal, or familial activity through the use of any device, regardless of whether there's a physical trespass, if this image, sound recording, or other physical impression could not have been achieved without a trespass unless the device was used. And that gets to your zoom lenses and your drones, which can't be done. Now, there's one famous case, which is an outlier that you may have heard about, and that involves Barbra Streisand. And so it's a very unique fact pattern. It really is the outlier case that shouldn't be relied upon, because there, a person had taken it upon himself to photograph the entire California coastline to track changes to coastal access in the coastline. And this was really for a sort of massive project. And so literally with a helicopter photographed the entire coast. Barbra Streisand learned about it, and because she has a massive palatial place right on the coast, she was concerned that a photograph had been taken of her house that could see into her property up on the bluffs. And as it turned out, his photographing as he came down the coastline did do that. So she sued, and she ended up losing that case because the court found that that type of photographic effort was a fair use one for a different purpose, and this didn't constitute an invasion of privacy. So you can't take any solace in that case. If you're wanting to investigate Barbra Streisand or anyone and you go out and target them with a helicopter or a zoom lens off of a boat to look in there, you will be in trouble and violate the law. So, what does this mean for you and your private investigator wanting to gather information? Well, it means video shooting and photographs should only be done in public of people while in public. Don't ever physically trespass onto private property and record. And by that I mean don't walk onto their property and record, but also don't, from the sidewalk, launch a drone over their property and then record, because that too is a trespass under these provisions. You will have problems if you trip those rules. And so these privacy laws that are really a creature of modern law really circumscribe what a private investigator can ultimately do. And so now we've seen, as we're marching through these legal regimes, so many different aspects of this discovery gathering type process that you'd want a PI to do that are heavily regulated, which you, the lawyer, need to know. So let's go to the next slide. Now we're going to talk about, well, we'll put on a disguise to trick someone, right? You know, the old Sherlock Holmes, disguise to go out and trick people. Well, this too is regulated by invasion of privacy rules. And so here's a general rule. Offensive conduct aimed at gathering information by way of feigning relationships or other deceptions to build personal rapport with people, to infiltrate their confidences, can in fact rise to the level of an invasion of privacy. They also can trigger those specific rules for private investigators under the Business and Profession Code we talked about earlier in terms of constituting acts of dishonesty or fraud. These bind the lawyers who are relying on them, and the scope is actually pretty staggering as to what could be deemed, quote unquote, dishonest for the private investigator to engage in. You have to think about things like, is failing to overtly identify the purpose of an inquiry, pretending to be someone you're not. Could that be an act of dishonesty? I mean, as you get into those types of very common transactions by PIs, you start getting into some hazy areas as to whether those constitute actionable acts of dishonesty. And some of this is unresolved by some of the cases that we're going to look at in terms of really what PIs can do when they feign who they are in order to gather information. And so let's look at these three cases coming out of California. And we're going to look at these in order, as these are really seminal cases and very important. The first one is Wayne versus Bureau of Private Investigators and Adjusters. It's at 201 Calap 2nd 427. And here, the private investigator visited accident victims at the home and misled them about who had retained him. There was no overt lie as he went in and spoke to the accident victims, but he did fail to disclose who he was, and he allowed a knowing mistaken belief of the accident victims as to who he was. The private investigator ended up being suspended because his behavior was deemed a disposition to deceive, betray, and mislead the interviewees. There was a lack of complete integrity. And so what that means is the private investigator violated the rule. If the lawyer hires a private investigator to do it, the lawyer now has trouble too for having someone as an agent go out and violate that rule. And that's a scenario of targeted deception, but without even an overt misrepresentation. So that's 1962. The California Supreme Court then picks this up several years later in 1971 and confronts a fact pattern as follows. And this is the Redner versus Workers' Comp case. The private investigator acted as a friend of an injured worker, hung out with him, got together, gets him drunk, they all drink, takes the injured worker horseback riding in order to catch him in the act of riding a horse to show he wasn't really injured. And they caught him. It turned out he wasn't injured. And so what really turned out, though, was that the non-injured plaintiff who had a fake claim or an exaggerated claim became the victim of this kind of a deception, and so actually had a civil claim back against the PI and potentially the lawyer. And the lawyer had the double problem that the evidence that was gathered in this enterprise, the guy riding the horse and someone being able to say, oh, he could ride a horse, he's fine, that was excluded from the case. This is the words of the Supreme Court. It's deceitful conduct. The private investigator may well make an intrusion into the individual's right of privacy, which would be objectionable or offensive to the reasonable man. Action for damages against the intruders. So that's a pretty stark and broad holding that could create real exposure and liability, not just for the PI, but for you, the lawyer, on the case. And so then we fast forward a couple years to the next case in California that's part of this trilogy, and that's Noble. There, PI by deception goes to a hospital room, gets the witness address, and ultimately had civil liability. And what's important here is that the lawyers could have vicarious liability the court held for this deceptive type behavior. Now there's a few other cases that you want to look at too, and that would be on the next slide, and we won't go through them, but these just sort of highlight the danger that you can have as a lawyer using third-party private investigators to gain access to information and solicit really personal private information. And if they're targeting in and engaging in deception to gain highly personal familial type information, questions of fact can then exist under the case law as to whether that's an invasion of privacy, creating blowback problems for you. So the next slide is, what can PIs safely do? Well, public record analysis is completely safe. Gather publicly available data and documents, that's fine to use them for that. Open, transparent investigations where they go out and talk to witnesses or principals and say who they are and who they're representing and what they're trying to gather to gain information, that's fine too. Posing to engage information, by posing in transactions, starts flirting with the case law that we just talked about. Gross misstatements and personal intrusions that courts would find socially offensive may well be unlawful. If it's more mundane, private, commercial type sting transactions, that's less likely to be held an invasion of privacy. But even there's no 100% guarantee. This is an undeveloped area of law with some very broad case law from the California Supreme Court. And finally, what's acceptable is physical observations, whether overt or covert, if done in public. So those are the key points to keep in mind in terms of what PIs can do. So now we're going to turn to the famous Hollywood cases that have created massive problems for lawyers who have interacted with private investigators. Round one we're going to talk about involves the PI, the notorious PI Anthony Pellicano and attorney Christensen. And we'll be looking at wiretaps, attorney-client privilege invasions, and federal prison. And then we'll turn to Hollywood round two, which is the fast-breaking, emerging story coming out of the Harvey Weinstein scandal and the investigative efforts that have been employed allegedly against Rose McGowan, the famous Hollywood actress. So let's start with round one, and here are the facts. And this comes out of the Ninth Circuit decision in 2015, ultimately affirming convictions. It's reported 828 F3rd 763. And here are the general background facts. Pellicano was a really well-known private investigator in Hollywood, and kind of famous for being able to gather all manner of information in very high-profile battles. And so the underlying legal scenario was as follows. Attorney Christensen had a client. The client's name was Krikorian, the famous billionaire. And Krikorian was in a massive custody battle with his ex over child paternity. And there was, at root, the issue was, whether Krikorian was the father of the child or not for purposes of this paternity battle. And so there's this sort of massive issue out there. And one of the things that's done in this massive case is, attorney Christensen hires Pellicano to gather information and, as the opinion reports, to wiretap the ex-wife. So Pellicano then goes off and does what he does, and he starts intercepting conversations between this ex-wife and her family, conversations between her and her friends, and even conversations between her and her lawyers. Attorney Christensen and his firm ended up paying Pellicano over $186,000 for these private investigative services. And what happened ultimately is the FBI, in a completely unrelated case, started to monitor Pellicano. And they issued a search warrant to go into Pellicano's place. And as they were going through his files and records and whatnot, they found 30 recorded phone calls between Pellicano and attorney Christensen, and this is sort of the irony of, or perhaps the attorney should have known, but Pellicano was recording his own conversations with Christensen without telling Christensen, as Pellicano told Christensen about his recordings of Krikorian's ex-wife. And so all of those conversations Pellicano is recording, who knows why. In any event, the police find all this and the FBI finds this and is no about stunned and fascinated. And the legal fallout, as we turn to the next slide, is that Pellicano and all the folks he was working with were indicted, but so was attorney Christensen. Attorney Christensen was indicted under federal criminal law, 18 U.S.C. 2511, for conspiracy to intercept and the interception of wiretapped communications. And the federal law is pretty simple. It says, absent consent or some other highly relevant exemption which didn't apply, it is per se illegal to intentionally intercept communications over the wires. And that's a general statement of the law that I've given you there. And there are additional penalties that apply for subsequent disclosures or use of those intercepts. And so Christensen went to trial, and his basic defense was, I didn't tell him to wiretap. I didn't know what he was doing. I'm just the lawyer. He was out doing all this stuff. He reported it to me, but I wasn't a part of this. He was using his own means. I'm not in control of him. He's his own professional doing his own thing. And the court effectively here said, you don't get to be an ostrich and stick your head in the sand. And moreover, it appears you wanted him to wiretap. But even if ultimately you didn't tell him to go out and wiretap, he was on a phone call with you reporting to you the substance of what had to be wiretapped communications. And you had to know that. I mean, when he told you about his conversations with other lawyers or with friends that the ex-wife, was having, the only way he could have known about those conversations was if he had wiretapped. And so all of the information and knowledge was imputed to Attorney Christensen, who was then convicted by the jury and, found himself, having to now stare down a federal district judge to figure out sentencing. And here's a quote from the federal district judge, who not only gave Christensen a sentence, but actually enhanced the sentence and made it longer. And here's the quote. There's no question that the base offense level does not begin to account for the scope of this particular crime, the invasion of the attorney-client privilege, and the direct and collateral damage to the justice system, as well as the massive invasion of privacy it represents. The court finds a 3-level upward departure is appropriate. And so ultimately what happened is what was under the criminal laws a 21-month sentence became a 36-month sentence, almost doubling in effect, because Attorney Christensen was found to have abused the public trust and was ultimately held to be the master of, private investigator Pelicano's efforts. And this was based on the fact that he had told him to wiretap. He knew he was wiretapping, and so he was deemed that Christensen was actually, under the criminal laws, deemed a leader of this criminal enterprise. So the next slide really gives the major rule and a practice pointer. And this is critical for all lawyers using PIs, if you ever use a PI, and that is that ignorance of how the private investigator gathers the information will not absolve you. There's no ability to be an ostrich so that you can then turn around and claim that you had no idea that laws were being violated. The very nature of the information that's transmitted to you by a private investigator can put you on absolute legal notice that violations have occurred. So if you're being told about wiretapped communications, you have a problem. If you're being told about things that obviously constitute invasions of privacy or illegal GPS tracking or other such things such as we've talked about throughout this presentation today, you can have real exposure and problems. It may not always be criminal as it was for Attorney Christensen, but it certainly can be civil claims and certainly ethical claims with the bar. So it's basically an area that if you're going to tread in, you must tread very, very carefully. And the strongest, safest advice is to be conservative. Don't engage in it at all. Get the information through discovery. I mean, if in that case, for example, if they were in a battle over the paternity of a kid and there's a legitimate dispute as to whether this child is the client's child, eventually you can find it out in discovery by doing genetic and blood testing and whatnot, and it will all come out. You don't need to engage in this in those kinds of nefarious activities to gather basic information. So the safest route is to use the discovery processes we have available to us as lawyers and don't take any risks for your bar license or your liberty. Now we're going to turn to Hollywood round 2, and this is coming out of the Weinstein scandals. And what we're going to look at is this emerging issue, which really is sort of hitting the press as you watch this video in late 2017, and that is involving Rose McGowan and Harvey Weinstein and the sort of investigative efforts that Harvey Weinstein wanted to use to find out information about Rose McGowan. And it's really a fascinating story involving, Rose McGowan, Mossad private investigators, these sort of highly trained Israeli spies, basically, and David Boyce's law firm, who is in the middle of all this in terms of the PIs. And so, on the next slide, you can see just some of the headlines here in terms of the scandal and the fallout. The BBC there you see reporting that Weinstein accuser says spy allegations are terrifying. And you see the Hollywood Reporter reporting that Harvey Weinstein hired private investigators, former spies, to discredit accusers. So here's where the lawyers get involved in terms of what we know. And these are the reported facts from the New Yorker article and from statements from the David Boyce firm. And so the reported facts are as follows. There is apparently a lawyer engagement agreement between the Boyce firm and these Mossad PIs, stating that the PIs were to gather information and ultimately what amounts to potential dirt on claimants in litigations. And so what the PIs apparently did was pretend to be someone else to gain confidences. They created literally an entirely fake business, fake social media, biographical information. They created what looked like some sort of a venture fund. They came to Rose McGowan and said, hey, we're a venture capital fund that raises money for women's issues. We want you to be a spokesperson. And this went on for months, sort of courting her, claiming that she was going to be a keynote speaker and all that, in order to gain access to her, to gain information about what she knew, what she was planning to say in her unpublished book that was percolating out there about Harvey Weinstein. And so the question is it okay to pretend to be someone else to gain those confidences in that depth of level that the private investigator engaged in? And the answer is probably no. That is probably an invasion of privacy violation, because it is a lot like those 3 California cases we looked at that are not just arm's length commercial transactions, but they are sort of deep, targeted personal intrusions into someone's privacy. Now, the other thing that the private investigators were asked to do was to get a copy of this unpublished book of Rose McGowan's that's out there, because Harvey Weinstein wanted to know, what's she going to say about me? And so the question is that okay? And the answer there is no, too. Not only is it an invasion of privacy, but you have to start thinking about, when you're talking about getting a copy of someone's unpublished book, federal copyright laws. And so what's important here is the root behavior by the PI may well have fallen over many lines, but the question that has to be answered is the lawyer's role in all this. And so whether this is under the supervision of a lawyer is actually unclear. Here's where we start getting into some of the details we know. One hypothetical on our next slide is that this gets at possible attorney exposure. The first hypothetical is that the PIs were paid through the law firm to create an attorney-client privilege, in effect, but the lawyers were truly uninvolved, as it was effectively a fake transaction. And that is, in essence, what David Boyce has said. This is the quote from him in the New Yorker article, and the quote is, "We should not have been contracting with and paying investigators that we did not select and direct. It seemed like a reasonable accommodation for a client, but it was not thought through, and that is my mistake." So that may well create problems. California ethics rules put a duty on a lawyer to supervise their hired agents reasonably. That's 3110A. Fake contracts are not exempted, so it's not clear that you can have, just help out a client by making it an attorney PI engagement to attach the privilege, rather than have the client hire the PI directly. So even if the lawyer is entirely uninvolved, by entering an agreement, you may have a strict duty to supervise, and then you could have a problem if the behavior tripped the lines. And so that will be one interesting case to look at in terms of how it comes out. The second possible attorney exposure scenario is that the supervisor was indeed the lawyer in the law firm. And here you have an allegation in the New Yorker magazine is that the actual engagement agreement between David Boyce's firm and Black Cube, which is the PI firm, was for the PI firm, quote, "to obtain additional content of a book which is currently being written and includes harmful negative information about a client," end quote. And the law firm's engagement agreement had a $50,000 bonus, apparently, if the copy of this manuscript was produced, quote, "in readable book format," end quote. So, big problem there is copyright infringement. So as well as all the other trespass and hacking and federal and state invasion of privacy laws and all the laws we talked about, here you have to even think about copyright infringement. If one photocopies or takes photographs with a camera of someone's unpublished manuscript, you're now engaging in copyright infringement potentially, which has massive potential liability under our federal laws. And so it highlights yet again the absolute danger of engaging PIs in high stakes, big time Hollywood complex litigation where one may be pushed into a corner as a law firm and a lawyer where you're getting close to lines and the PIs are doing things they shouldn't be doing. The third scenario is that the private investigator simply did all of that stuff without any lawyer involvement whatsoever, without lawyer requests to do any of it, and indeed without even any of the lawyer knowledge. And there we'd have to, assess ultimately whether this was a master-servant relationship, whether fake contacts would really bind the lawyer, or if the liability would stop at the level of PI. But even all that aside, even if the liability stopped at the level of the PI, under the California case law we talked about, there's still potential negligent hiring, negligent selection, exposure litigation, and that's civil exposure vis-a-vis Rose McGowan. I mean, she could have such claims against law firms for negligently hiring the wrong people, and that's those California cases we looked at. And bonus structures for certain information, former Mossad spies and whatnot, that starts getting close to the question of, what did you think they were going to be doing? So the conclusions and lessons you see here really are pretty simple. Deep covert work can come to light in a spectacularly difficult way. So there's big reputation risk, be careful. We're in a highly regulated modern world. This isn't the time of Sherlock Holmes. And so there's privacy laws relating to all aspects of data discovery, financial credit, computer, audio, video data that you may want to get, and you need to work carefully in that. Heavily monitor PIs if you're going to use them. Court won't let you be an ostrich. Thank you very much for listening. I hope you found this walk through the law of private investigators useful.